Welcome, CREA, to our first in-person general membership meeting in 16 or 17 months. We made a conscious decision as soon as it was open back up that we were authorized to try to get back in person because of your ability to have the interactions that you just had and the dynamics that come into play for this organization when we're able to get together. And I'll mention a few other things that we're going to be doing in the near future that are back in person. So we're really excited about the opportunities that is opening up. Welcome to the general membership meeting. As always, I've got our mission and objectives up there. I think it's a good idea every time we get together, just kind of look at that, reflect upon it, and make sure that when we join together, that we keep our mission statement and the objectives thereof in mind. And I can assure you that every time our board gets together, we look at that, we read through it, and we think about how it is we can further that mission statement. Speaking of the board, I can't say enough positive things about this group of people. It's been an interesting year or two to be on the board here at CREA and try to come up with ways to still do value add given the scenario that we were in, and all of those people put in countless hours helping deliver the programming and the education and the different things. So thank you for everybody who's listed up there. If you see them, yeah, go ahead. Another thing we couldn't do much without is without our sponsors. I want to say thank you to our gold sponsors, Patten, Ebling, Stable Palm Bank, Center State, silver sponsors, Shumaker, Loop and Kendrick, Synovus Bank, Atlas, and our bronze sponsor, Gulfside Bank, Lakewood Ranch Commercial, Adria Bank, soon to be First Horizon, and Achieva Credit. Thank you. Speaking of, we're going to go ahead. Our featured sponsor today is Gulfside Bank. We have Tom Martin, who will come up and just speak a little bit about the bank.
There you go. I'm Tom Martin. I'm a Chief Credit Officer, Senior Lender for Gulfside Bank. We appreciate, I appreciate the opportunity to be able to speak to you guys today. Gulfside is a proud sponsor of CREA. It's been a crazy last 12, 15 months. As everybody knows, it's nice to kind of get back to hopefully some normalcy and get, from a banker standpoint, be able to get out and call and get face-to-face with clients again. I'm sure you guys like that too. A little bit about Gulfside Bank. So we started the bank back in November of 2018. Basically, 3 or 4 of our existing board members got together, thought that there was a opportunity to start a community bank again. We got with Mr. Dennis Murphy, who is our CEO, and from there they kind of formed a team, and we got the bank started November of 18. From there, we've been in business 2.5 years. We're full service bank, probably focus on the business side of things, doing commercial real estate, owner occupied, non-owner occupied, equipment financing for small business. Obviously, we also do, as a full service, we do consumer financing also, residential lending, do the full gamut of lending. So in 2.5 years, we've gone from a startup situation for over 200 million in assets. So we're very proud of that. In about 30 months, we were recently awarded a 5-star rating from Bauer. So that's that 2.5 year mark. That's a good sign. So we're very excited. We've recently had a couple new hires. We've hired David Newton, who heads up our SBA financing. So we're going to be active with 504 financing and 7(a) lending for any small business. We've also recently hired Beth Green, who's going to head up our private wealth division. She'll work with our investment division and help kind of create some fee income from that standpoint with the bank. The other two, again, as a commercially driven bank, we have Jeff Berkey. So we've got very seasoned lenders that have been in the market a long time. Jeff Berkey's our Sarasota executive. He's basically been in the market 20, 25 years, seasoned, does all types of financing. And then we have Ron Beck, who represents us in Manatee County. Again, both of those guys are seasoned lenders with lots of experience in this marketplace. You know, community banking, it's all about trying to differentiate yourself from big banks. As Neil and Rick can allude, you know, you're trying to differentiate when you're talking with a client. You can't kind of leave a price. So you need to have the people in place, and it always gets down to people. And we've got very good people that can sit down with clients, go through a request, make sure it makes sense, help them with structuring it, pricing the deal to where, you know, hopefully they have a investment, a loan that makes sense, that, you know, they can make a return, we can make a little return. But, you know, we're very excited about opportunities looking forward. You know, I think it's interesting, I won't give too much opinion, but residential market is obviously very dicey hot, not necessarily normal. Commercial, I think, is coming back, and if there's obviously anything, opportunities out there, and any type of real estate financing, please keep us in mind. Thank you.
Okay, so it's my pleasure to introduce today's panel. If you missed it on the first slide, we're here to learn a little bit about leases, lease clauses, and some thoughts. And we've got just an incredible panel for you here. So let me introduce them in order, starting in the middle. Saralyn Dorrill was born and raised in Sarasota, is a board certified real estate attorney with Shumaker, practicing in Sarasota for 28 years. She has 2 stepchildren, ages 31 and 34, 1 son, aged 14, 6 grandchildren, and 7 and 1 career changed. 6 grandchildren under 7, and 1 career changed Southeastern guide dog, Jenny. Saralyn went to Universal Studios last weekend with 144 children, only 1 of whom was related to her. It was a costume. Saralyn's favorite pizza is the margarita pizza from Mediterraneo's. Saralyn's favorite color is deep purple. I think that's like royal purple, but I'm not sure. The secret to Saralyn's marriage is that her husband fixes her a heart-shaped mocha every morning. Adria, on the far side, has been practicing in the area of litigation for 16 years. She is a Supreme Court certified circuit civil mediator. Adria was born and raised in Miami and spoke only Spanish until age 6. She has 2 children, 13 and 11, and a 3-year-old min-pin, Alina. She is quite content with her chosen career path. In 2 weeks, Adria will be going to Universal Studios with 14 other people, all related to her. Her favorite pizza is Hawaiian pizza at Michelangelo's, and her favorite color is red. The secret to her marriage is that her husband always says yes when she asks him something. Anastasia, closest to me, has been practicing in the area of real estate for 25 years. Anastasia was born and raised in Falls, New York. She has 2 boys, aged 8 and 1, and 3 Australian Labradoodles, Crockett, 11, Haley, 11, and Marlo, 9. Her favorite pizza is veggie from Donato's, and her favorite color is also purple. The secret of her marriage is travel. All right, thanks guys. Well, it's great to have you here, and we look forward to your presentation. And just so the group knows, I think that we're trying to have kind of a Q&A kind of back and forth. So I will be there if anybody has a question at any point along the way. I will bring the microphone over to you, and we'll get going. Thanks.
Just want to make sure it's on, or no one has ever told me I need a microphone. So welcome everyone, thanks for joining us. If our bio sounded a little strange, it's because we figured you hear all about everybody's accolades every time you go to one of these things and you never remember anything, but I think you'll probably remember something from our bios this morning. So thank you for that introduction. My name is Adria Jensen. I'm a partner along with Saralyn at Shumaker, and I work in the area of litigation. So this is not really my show, this is their show, but I'm gonna pepper some of the tips with some pitfalls and some things that I see on the litigation side when things don't go the way that they should. And then Saralyn calls me and says, okay, it's time for you to get involved. So we'll try to give you some things to think about that hopefully will keep you out of litigation. Although people usually say like, I don't want to talk to you, I don't want to see you, I'm kind of like the dentist. And I always say, just like the dentist, it is better when you talk and you deal with these issues on the front end than you wait until, you know, you have the cavity and the tooth has to come out. So think about that in your negotiations. Sometimes it's good to talk to a litigator, get some idea about why something should be a certain way or not be a certain way. Here's some war stories. Sometimes people think, well, that'll never happen. Just talk to a litigator. It's happened. It's like farmers. We know a thing or two because we've seen a thing or two. So we're gonna start today. Again, real quick, I'm just gonna give a brief intro in the sense of kind of prepping you for what these ladies are gonna talk about. And that is the importance of the lease itself and the words on that lease. And that sounds like a really obvious point, but you'd be surprised at how many times we get questions where people say, well, can I do this? Can the tenant do this? Can the landlord do this? And what's our first question? What does the lease say? And so there's a lot of things that people really glaze over or don't think about. We have a tendency, especially in today's world where everything is, you know, automatic and quick and easy and, you know, to just use cookie cutter type of things, download a lease that you've used a million times. We get people who say, well, I've used this lease for 20 years. I use it all the time. Well, I hate to tell you, but in 20 years, a lot of things have changed. And so it is very important to think about, you know, customization, not of everything, but certainly different parts of that lease. So very important, words mean what they mean. And maybe they don't mean what you think it means at the time, but I can assure you that when I have to go in front of the judge, the words matter. And what you meant doesn't matter as much. So that's one of the nuggets to take with you today. I'm not doing a good job of this. I'm a talker, I'm not a good visual person. So the other thing to think about as we're going through this is individual provisions. I just pointed out how important the words on the lease are, how important the lease is. And so after you have your provisions in place, it is important to follow them and it is important to enforce them. Is it a use it or lose it situation? And sometimes it can be. If a landlord, I'm saying you, but obviously we're talking about clients. If a landlord lets things go to a certain extent, there may come a time when it becomes very difficult to enforce those provisions because you set a standard and you set a way of dealing that is a little bit difficult to claw back. And the same for the tenant. If the landlord is not meeting certain responsibilities, it is important to address that. And you can do it in an amicable fashion, but you certainly want to do it. Because when you don't document it and you don't exercise those provisions, again, it becomes very difficult to claw that back after you've set a standard of dealing for a period of time. And that's my skill for now. So we'll go on to talk about some specific. All right. Yeah. I'm gonna get ahead of you.
Pointing this way.
That way.
And we're actually going to go a little bit out of order because Anastasia and I already got a question that we want to get to out the gate in case we don't get to that. So one of the questions we had this morning was someone has a lease that they're preparing and there are the 2 witness blocks on the lease. Do we still need to use 2 witness blocks? The answer is no. There are no longer, the statute no longer requires 2 witnesses for a 1-year lease. So that just recently changed. And again, like Adria was saying, that 20-year lease, that the form you always use, the witnesses blocks can come off of a lease now when you have it signed. Right, late delivery of premises. So one of the areas that when you're negotiating a lease we're just trying to do this like chronologically in order of what you would see in the lease, is if, say, for example, you sign a lease, it's effective that date, the landlord is going to go ahead and is obligated to build out, say, the tenant's portion by a certain date. And during that time period, there is no rent that accrues. So you think if you're if you're representing the tenant, you think you're protected because you're not paying rent during the period within which the landlord is building up the space. Where you can maybe try to get ahead of a problem is the scenario where the landlord, they're exercising due diligence, they're acting in good faith, but for some reason or another, maybe not their control, contractor defaults, city's behind in permitting, materials aren't available due to COVID or whatever it may be. There will be a time period within which the tenant is going to be like, we are now 30, 60, 90 days past that date that I was supposed to get into the premises, and I need to have the ability to maybe terminate the lease. Maybe it's not the landlord's fault, but there's a point where the landlord might say, I need to find a new tenant that has different build-out requirements. So when you're negotiating that provision of the lease that talks about build-out, have an outside date by which either party can terminate the lease. And also, if you're the tenant, you might have a situation where, oh, this is great, the build out is estimated to be completed by January 1. My current lease expires December 31. If the build out is not completed by January 1, you're going to have a situation where, oh no, I am now as a tenant paying holdover rent. I now have to find a swing space to move into while the landlord's building the space and it's later and it's a delay. So you might want to have a compromise situation where at least you could build in for every 3 days a landlord exceeds the build out date, the tenant gets $1 rent credit and so forth. But you want to think of these things in advance, because if your lease is silent, then you're stuck. So that's a provision that we like to see fleshed out a little bit more than it typically is when negotiating the lease.
And on that note, I do just want to share this one story because it is very telling of how important these provisions are. And this is one of our partners who actually took this up on appeal and was successful. We represent a commercial landlord. They had a space where they rented out to Zoomtan. Have you heard of Zoomtan? If you look this up, it's a published opinion, so I'm not divulging any information you wouldn't know already. But Zoomtan rented out this space and then applied, and it was not here locally, it was, I think, in Collier County. They had applied for the use permit to open this salon, and it was denied. Zoomtan then took the position that, well, it was denied, it's impossible, I can't proceed with the lease, so we're going to terminate the lease. Our client, the landlord, said, no, you're not. The lease does not say it is contingent upon you getting this permit or on the use. So you're stuck with this lease, that's your issue, you will have to figure this out. Zoomtan did not try to get an appeal, did not go to the hearing, did not do anything to try to get this reversed, and just rested on the fact that, well, I can't perform under the lease because of this situation. Well, there was a provision in the lease that actually said affirmatively, it does not depend on the use. It does not depend on whether or not you can use the space or the intended use. And that really saved the landlord, because at the end, the court said, listen, the lease says what it says. You are stuck with this lease, and the fact that you can't get this permit was not part of your bargaining in getting into signing the lease. And further, you made no efforts to try to get this reversed. So they were saying like it's impossible, but in reality, there were some things that they could have done per the county code to try to get this reversed, and they didn't do it. So that having that provision really saved our client from losing out on that. And they did get an award for the full amount of the lease in that case against Zoomtan as a result of having thought that through and having that in all of their leases where it does not become contingent on lease. So.
And I think that ties into a provision that I do not see in a lot of leases, and I try to advise clients on, is due diligence. Just like a purchase and sale contract, there should be a due diligence provision, and the tenant should obtain engineer reports, surveys, appraisals, making sure that the use is allowed for that space. And I hear sometimes people say, well, I drove by and it's a shopping center, of course I can have that, or I drove by, it's an office building, I can have that in there. And I always ask, do you know if you can for sure legally? Do you know if your use is permitted in that building? Do you know if there's exclusives within that shopping center? Do you know if the square footage is allowed for your use? There's a lot of questions that I ask, but I usually get a blank look on their face, like I have no idea. And so I always suggest in a lease to have a due diligence provision, just like you would in a purchase. It's just the same investment for a tenant. And from a tenant perspective, from the landlord, I'd like to put it in, but I don't always require it. I usually leave that up to a tenant, but if I'm obviously representing a tenant, I make sure that that's in there to just, absolutely be certain that their use is permitted, and that, excuse me, that the survey is provided, that the shopping center is also up to code. There aren't any violations, or the office building doesn't have any violations. There aren't any fire code violations. Or environmental issues. Those are all things that people don't think about when they're getting into a lease. They're excited to put their new tenant in. When I discuss it with the broker, they're excited they have this great tenant that they're working with, but they don't sometimes think about those things until, unfortunately, the lease is signed, they're going in for permitting, or they're going into that space and they find out, oh, there's a lot of issues here and there's nothing in the lease to protect them.
Yeah, and you mentioned exclusives. That's a good point too. You have to think not only about what your current use is, but if your client or the tenant going into the space, what the future expansion of that business may be. If they look around and they say, well, there's a Publix, but I'm not going to sell food, right? There's a nail salon, but I do hair. Okay, you got to think through that. Does that mean you can't sell hair products? Does that mean you can't add, or does that mean you can't add a nail station? Does that mean that you can't sell health food if you're a gym because Publix is in the same plaza? Find out what those exclusives are. Don't assume, well, it doesn't affect me right now. Okay, well, but it might. Are you adding a cafe to your store? Are you adding, a store to your cafe? How might this stop your growth in the future? And as a landlord, how might this spew what kind of tenants you can attract in the future and what kind of people you can put in spaces based on who you're putting in there and what those leases say in terms of exclusivity. One final point on the Zoom case, the reverse is also true. A tenant could go in and know that they're maybe going in to get a permit for something that the city may not approve or that the county may not approve, and may want to put a contingency in there or a provision that says, if I cannot get a permit or a liquor license or whatever it is within this period of time, then I do have an escape hatch, or I have a way to come to a termination of the lease. That might be a hard sell for a landlord, but you never know. There might be a space where a landlord is willing to do that because it hasn't been rented for a long time, and they'd rather take that chance and give you the 60 days or the 90 days to explore it.
And from a landlord's perspective on exclusives, I think a landlord also would want to have limitations on exclusive because they're limiting their market of who they're going to be able to put in those spaces. So if there are exclusives, sometimes you just cap them at a certain limitation, like the hair salon, they can sell products, but to a certain dollar amount or a certain percentage of the salon can be used for retail space. So there's ways of working on exclusives, and it's just as important, I think, for a landlord, especially in our market. We're a smaller market, so you have a smaller group to work with.
I was just gonna add that some of these spaces are within commercial condominiums, and it always surprises me, nobody looks at the documentation. And sometimes the commercial condominiums, like out in Lakewood Age or whatever, will have sections that apply to uses. So you need to, neither the landlord or the tenant is looking at that. So you need to title as one of your due diligence items. So you're right. Yeah. Unclear allocation of maintenance and replacement responsibilities. So obviously a big area of problems during the life of the lease can be who's responsible for what. So one of the first things that you want to do is have a provision in there like the landlord shall repair, maintain, replace any aspect of the premises that's not allocated to the tenant, otherwise set forth in the lease. Something that says, what is the default provision? Another thing that is typically negotiated back and forth is you've got, clearly the landlord wants to put everything on, shoulder the responsibility of certain items on the tenant. The tenant doesn't want to be responsible for items that would be considered maybe capital expenditures that are going to benefit the landlord over the life of the entire building, maybe not the next 5 years. So one of the things that we do in our leases, I'm sure a lot of you are very familiar with this, is we put something in there like the tenant shall repair, maintain, and replace all items up to a certain dollar amount, like $5,000. That way the tenant is incentivized to take stewardship and ownership and take care of the premises. But there's big enough, if it's something over 5,000, maybe it's inequitable, not fair for them to be responsible for it, then the landlord takes it from there.
And I think I see a lot of times that landlord is putting the onus on the tenant to replace an AC unit. That's a difficult discussion to have with a tenant when they send you the lease, and their lease is very clear that they have to repair and replace the AC unit. I had a restaurant call me, and they were in discussion with the landlord over that provision. It was very clear that they were responsible for it. However, it was a little tricky because the roof was the responsibility of the landlord. So now they're going to go on the roof and replace the AC, but if they don't do it properly, they may, they're going to be pointing fingers at each other because the landlord's the one with the roof, tenants with the one with the air conditioning. So there should be something, if you should, that provision, a lot of people glaze over, they don't catch the word repair and replace. I always leave repair in to a dollar amount, but I take out replace usually for a tenant if I can. And if I can't, I always specify the issue. If it is to be replaced, the landlord and tenant will work together. Because of it being on a roof, you don't want to be punching holes and then there being issues. So that to make it clear in that provision, just be aware of that and don't glaze over that, because that call unfortunately didn't even have a dollar amount in it, and they were responsible to replace the entire unit, and they only had 2 more years left on the lease. So they had already used all their options to extend, and they weren't in a very good position. So that is something to really be aware of in the lease provision, maintenance and repair.
If this spurs any questions from folks, just raise your hand. I'll bring the mic over to you. Yes, Susan.
Specifically to the point of if you're representing the tenant and you are required to replace the AC, and let's say you've got 6 months left and you're willing to put a Band-Aid on it, is there language that will allow you, in your sole discretion of the tenant, their sole discretion, to be able to make the decision of whether to repair or replace?
That's a good question. What does the lease say?
I guess the question becomes, what can the lease say?
I actually remember once, sorry, it was like a few years ago, we negotiated something and literally in year 4 and 5, we're only going to do X. I mean, we spent a lot of time drilling down on that. And I say it was a nightmare, but who knows, maybe it saved the tenant, $20,000 or something.
I've seen a lot of leases that also have a clause that'll allocate it to where you take the service life of a piece of equipment and AC maybe 10 years, and then it's amortized and you only pay the portion for which your lease still provides. So you're paying for the time that your lease provides, but not for the rest of it. And I've seen that kind of solve those solutions if it's put on the front side.
Well, the other tricky part with an AC is that the question I asked the tenant was, do you know how old your unit is? Did they provide you documentation? And they didn't have any documentation. So it could have been, when they entered into the lease, it could have been a 20-year unit to begin with. They didn't know it. So that's another due diligence item of, if you're going to be responsible, even for repairs, you should know how old the unit is. You should have your own AC person come out and look at it, inspect it, because you're obviously relying on the property management company to say, oh yes, it's fine. Well, what's fine? How old is it? How many repairs has, do you have a record of the services on it? Those are questions to ask during that due diligence period that you should be putting in the lease. But if you don't have it in the lease, the other option is in a 6-month situation, tenant could walk away from the lease. They could weigh their options. I only have 6 months left. Is that cheaper than putting a unit in? That may be another option. Obviously, the landlord could come after them for other things, but if they just, that could be the risk that they weigh and decide, well, we're just going to close up and leave them, find another space.
Can I ask a question on holdover? You mentioned holdover rates right at the start. I've seen holdover rates from 125% of the current passing rent to 400% of the current passing rent. Is there a reasonable number? Because I get itchy above 200.
The default is double. Default is double. It has raised an eyebrow for me when I've seen it, even at anything over 100. What's reasonable, I would be honest, I have not done any case law research on that. The statutes don't specifically speak to that or say, this is what's reasonable. I mean, I think you can start from the position that, you know, if the statute says double, you start from double being reasonable, and then anything above that, you might have, you know, you may have a judge that has a little bit of heartburn over it. Or like I said, the case law may speak to that. They have been cases where courts went one way or the other. But you know, definitely something to look at when you're signing a lease, like, hey, this looks very unreasonable. Don't rely on the fact that, well, it's unreasonable and no court will ever enforce it, and never go from that position, because it, you know, any litigator will tell you there's all kinds of ways in which the courts interpret things. I would just from my gut would tell me 400 is probably going to be knocked down as some sort of penalty, or you know, some way of the same way that sometimes the contract will say there's a penalty if you do things and the courts don't like that. I think that would be seen as a penalty as opposed to a proper way for the landlord to recover, or an incentive for the tenant not to hold over. I mean, that's really what the statute is trying to do. I think when you start getting up there, the courts will look down on that.
We've got some relatively new agents looking around the room. Can you delve into what holdover is? When you talk about the statute saying that it's double, if the lease is silent and doesn't have a clause, does the statute take effect? Can you talk to that?
Yeah, so if a tenant fails to vacate and turn over the premises at the expiration of the lease without permission, so you can always work that out. A landlord could say, I'll extend it, even if they don't do it in writing. Of course, we would always say, get it in writing. Tell the landlords, don't just say, okay, get it in writing, specifically say what you're agreeing to. But if the lease just sort of expires, sometimes people don't realize it, they just continue to pay the rent. And so they're, in a way, they're a holdover, but really they become what's called a tenant at sufferance, which is they don't have a specific lease or agreement, but we're assuming that the agreement they had is just kind of rolling over. If it's without permission and the landlord is demanding possession of the premises and the landlord and the tenant isn't leaving, or maybe the landlord says, all right, I'll let you stay, but you're a holdover, so I expect you to pay more than what you were paying. If the lease doesn't say, then there's a statute that says that you can demand double the amount of the rent that was due during the time that the tenant is there as a holdover. So let's say the tenant is only there for half a month, you would get a prorated amount, double the rent for the you know, the 15 days that they were there, or whatever the case might be. Did I explain that correctly? Excellent. But I'm just arguing it. I'm not. Oh, control.
We have, this is one of the points, because I'm starting to see special fees just in the past couple weeks, actually. I've had leases where there are tenants that are going to be using the space 24/7. And not everybody is going to be there. For instance, one is a radio station. The second one is a flex time space for people to come and go. It's a kind of a more creative setting, and they want people to be able to come in and work at their studio space when they have the inspiration. So for those particular leases, we've put in a special fee for AC, because the AC in the buildings for both of them goes off, or, you know, doesn't go off, but it gets higher at the end of the business day. So they're paying for unlimited air conditioning. They're paying a certain fee per month, rather than trying to figure out how much more they need or adding additional units for them. They're paying unlimited amounts. There's also provision in both of those leases that if that fee for unlimited amounts isn't working, that they can put in units for themselves at their costs and making sure that they include the landlord in all of the permitting process and where they're going and the plans and so forth. So that's one fee that I'm seeing recently, is that on the special fees for the air conditioning. The other fee I'm seeing, oh yes, the trash and the restaurant, and for restaurants, and also water. In the leases for like a hair salon, for instance, or a restaurant, they're using more water. And so rather than trying to figure out the percentage, sometimes a landlord will put in a higher percentage for that tenant based on the fact, based on their use. And sometimes they'll just tell them that they're paying X amount for that extra water that they're using. Same thing with garbage for trash. Restaurants tend to need trash for pickup, and that's usually, sometimes it's daily. So what a lot of the leases that I work on, especially with a tenant, is they will agree, I'll be responsible for it, take that out of my CAM, and I'll set up my own trash removal. I'll pay no fees to you, but there'll be a provision giving the tenant the responsibility. I like to see it that way because it's in the tenant's control. The tricky part is the landlord doesn't necessarily like it because it's already built into their CAM. They don't want to have to recreate a CAM charge for them. So it's a little bit of a back and forth on calculations, but I've managed to get that removed and the CAM reduced based on the tenant taking over the responsibility for trash. Water is a little trickier because there's usually a meter, and sometimes they share it with a building. So they try to do an allocation, higher allocation than they would normally for, a T-Mobile store that, doesn't even really use water except for the restroom in the back. So those are some special fees and considerations to look at in working with your tenants and landlords as well.
ADA compliance. We have one of our partners in Tampa practices predominantly in ADA compliance, and we give you a lot of information, but just in a nugget, make sure you expressly put in your lease who's responsible for ADA compliance. And if you are a landlord, and typically it'll say something that if the tenant adds material alteration, then it's subject to the landlord's approval, and the landlord's like, oh, my tenant wants to remodel the bathrooms, I give it, my approval. And you have a sink, and they decide to put a cabinet below the sink, and I guess the wheelchair can't get under to reach the sink. And all of a sudden, as a landlord, you may have inadvertently waived. You might have a provision in your lease that says the tenant indemnifies you is going to be responsible for all compliance, including when they do an alteration. But if you as a landlord have approved of an alteration that is not ADA compliant, it can get really tricky. So be mindful of making sure you expressly identify who's responsible for ADA compliance, and be mindful to tell your landlords when they approve of an alteration, make sure that it is ADA compliant. And also, basically, our litigator was like, if you're going to get, everybody's going to get sued. Doesn't matter what your lease says. It matters what your lease says when you're fighting it out between the landlord and tenant, but plaintiff's going to sue everybody.
And I think for the ADA, a lot of times there's a provision that a tenant may want that a landlord's representing that their building is ADA compliant. Be careful with that if you're representing a landlord, because it may not be currently up to code for ADA compliance. It may be an older building that is not. So make sure that that ADA compliance provision is carefully looked at to make sure that you're not representing a landlord. He's signing off on that. Tenant goes in, and all of a sudden, the landlord's now going to have to make the building ADA compliant.
Next one. The big one.
You want to start with that?
So for this provision, I've had tenants be concerned with this provision because obviously they don't want to continue to pay rent if they are not allowed to continue to use their space based on the pandemic we just went through, or continuing. I don't know what to say on that, but so what the language that I try to put in is that if there's a pandemic, or if there is a federal or a state of emergency, or rules or looking for. Anything that's come out, moratorium, then we, then the tenant is not going to be in default. And we put a provision in there that landlords like to limit it and say after 15 days. I like to say until the moratorium is lifted. We try to kind of meet halfway on that, but I'm seeing tenants being really concerned with, if we ever go through this again, I don't want to have to be on the hook, because I've had tenants that have been on the hook, weren't able to operate. Now we're in default, we're looking for rents, and the landlord was looking for rents, and put all the parties in a precarious position. So.
I had a question, talking about the pandemic, and I didn't have a pandemic in my lease provisions. I had a Crunch Gym, okay, up north, and they stopped paying. Obviously, they weren't able to occupy, and they occupied, but it was moratorium against using gymnasiums. What's the best way to enforce the amount that's due afterwards? Because obviously we weren't able to collect, and we're in a situation now of wanting to recoup, and what do you suggest that we do?
Well, so from a litigation perspective, I'll start off by saying that you have to remember when a tenant signs a lease, they're agreeing to pay X number of dollars for this lease. The monthly amounts is a consideration to the tenant so that they can pay it in installments, but it's due. Whether you operate or not, whether it's closed or not, whether the government shuts you down or not, the money's due. It's a contract. Now, the moratorium is really to prevent there being, just massive evictions and shutting, getting. I mean, it's not going to serve anybody. It's not going to help the landlord if every tenant they have, they kick out. But the money's still due. So even when you're going for an eviction or when you're going to sue for a landlord-tenant situation, and I don't know in that state what the rules are, but I can tell you in Florida, it's two parts to that. One is the eviction part to get the person out and get possession, or to terminate their right to continue to possess. And the second part is the damages part, which is if your lease allows you to accelerate, that's one of those provisions that everybody assumes is in a lease, but isn't always in the lease. But if your lease allows you to accelerate and say you can ask them to pay all of it that became due at the beginning now, then you're entitled to do that, and the moratorium is not going to affect that. Now, of course, the moratoriums are out now for most states, but the money is due whether they operate it or not, short of there being some provision or it falls into the force majeure. It allows for some abatement of the rent, or says you don't have to pay for that time that you were shut down. But as a matter of course, if everything's silent on that, the money is due.
I think the eviction has to be reversed. It can't be evicted until September. So there's still a situation where it remains. The question is, the personal guarantees that were both. So say there's a personal guarantee for, let's say, 3 out of 10 years. That has gone. So all we can do is go against their entity, their LLC. And, they can just decide to close up shop. That's what they're basically telling me. Is you want to kick us out, you can. Just close up shop.
Have you tried to negotiate with them to amend the lease to say, okay, we understand your situation because you don't want them to leave, and they probably don't want to leave. So to have them continue to pay rent, but put it on the back end so that that they're there and they catch up. So just going forward, they can pay what the rent is going forward, and then at the end you just add the amount of time that they have not paid is a suggestion.
And I would require, as part of that consideration would be that new personal guarantees are signed. So I'm not forgiving the amount, I will forbear it, or I will put it on the end, or I will split it up into various payments, or we'll work out a higher rent increase in 6 months. But you're going to agree to a new set of personal guarantees for that additional money that I'm taking a risk on. Negotiation is the key. We spoke to a lot of people during the shutdown while people are not working, both tenants and landlords, about what do I do? And the answer was, you're gonna have to be reasonable. You're gonna have to, for once, the lawyer saying, what's in your lease is not necessarily gonna be your best bet because the lease didn't anticipate this. So let's be creative. How can we keep the tenant? How can you get your money? How can you, sparse it out so both parties can be in a win-win? I think one thing that we talked about that going forward, we want to include in the leases is that the tenant is obligated to apply for any governmental assistance such as the PPE and all that. That too. Because some tenants just sat back and did nothing and just said, well, I just can't pay my rent. I don't care. I'm gonna, you can't kick me out. Whereas others were diligent in trying to get that assistance so that they could pay rent. And some of them got the assistance and chose not to pay rent. So, yeah. Right.
So I think another part of that, and we've got a few bankers in the room, passing all of that risk along to the landlord. Many of my landlords' responses during the pandemic was, well, I tell you what, if you can tell the bank to stop charging me interest on my loan, I will stop charging you rent. But that didn't generally happen, although there was some, excuse me, delayed in that way, and they passed that delay on to the tenants. But I'm just curious, are you guys allowing for that in new loans?
Well, I first like to ask attorneys up front if there's a way that we can make Joe Henry never say that to a client again. I think.
You have to talk to his wife.
Yeah, so I think what they're saying is absolutely right. Every situation was different, was bad. Nobody knew it was going to happen. And, I think being proactive in our situation, we try to be proactive and work with people. And now if the pandemic's over, closer, I think hindsight, everyone that worked with each other paid off by and large. And we work with a lot of landlords, we work with tenants, and the ones that work together and the tenants, you couldn't have a tenant saying, I don't want to pay, and landlord eats it all, and then, or the landlord saying you got to pay it all. There was a lot of giving up, and there was some of, I think you said abatement, or just taking, amortizing over the life of the lease, extending the lease. There was a lot of creativity we saw, and I think in our community, probably all of us see examples where we got through it. We're sitting here today, and most of the clients, the buildings are full, and we got through it by, I think, as what you said, is the lease doesn't necessarily mean where we're going to start. We've got to really look at something different because we've never dealt like this before. But no, we never gave up that we weren't charging interest. We certainly said we would only charge interest where we would defer it before, abate it back or whatever we need to do to help the process.
Any questions from the field?
I had a lease I worked in representative tenant a couple years ago who had a lease in a building in Tampa. And they had one of those provisions in the lease that said landlord may relocate tenant at any time. And it was like number 37 clause, like nobody pays attention when thinks, oh, the landlord's not going to do that. Well, the landlord did that. So the first question is that enforceable? Yes. So they were in a high rise and they had, I don't exactly remember, say it was 1,500 square feet, but they had a new tenant who was going to come into the building and rent the entire floor. So they were going to relocate this tenant to a higher floor. And the relocation provision was very sparse. It was like 2 sentences long. And it, didn't address, well, it said the landlord will, pay for the tenant's expenses, but what does that mean? If I have to move and I have to change my business card address, if I have to change, just changing the address was a nightmare. All the different things that you do when you have to move, those we needed to, it would have been nice if that had been fleshed out a little bit more ahead of time. Also, what space is the landlord relocating you to? Well, it was implied it was something comparable. And in fact, the landlord thought it was comparable because it was a higher floor, that might be a better floor. And it's had a view, which thankfully, because we didn't, the relocation provision didn't say like comparable space with the view. Well, it viewed a very undesirable billboard. So that wasn't good. And then they were sharing the space with it was a radiologist, and you get off the elevator, you made it right, you went to a nice professional medical, you made a left, went to a clinic, which was, at any rate, they shared facilities in terms of the kitchen. I can't say it. The
Not a
kitchen,
desirable tenant.
not a desirable, not a neighbor. So I remember they had a kitchen and bathroom facilities that they shared, and it was making people in the office really uncomfortable. The bottom line is we were great lawyers and we worked it out, and we got to move to a different space. But if you see that just thrown on the end of the lease, it's enforceable, and try to think even if you just write something like to a comparable space with the same view and, neighbors subject to our, now, the landlord's argument would be, we could have put that tenant in the remaining space next to where you were. I mean, there's two sides to everything, but that's something to be mindful of.
Now they're all wondering what was next door.
I can't say it.
Don't see me after, I'll tell you.
Along the same line, I always, I have leases with franchise tenants. And I always say your franchisors approved this space. So if you have a relocation, which never fails, it's in there, is your franchisor going to be okay with where you're going? Because you're saying I'm going in this space and they're looking at it like, great. But if you're in the middle of the shopping center and they're putting you in the corner behind the building, it's probably not going to be as a desirable location, because the relocation clauses that I've been reviewing recently have solely in the sole discretion of the landlord. It doesn't give the tenant an out. So at least I compromise, and if it's going to be in the sole discretion of the landlord, I give the tenant the right to review and have the option to terminate if this space is not acceptable to the tenant. It seems to work if their relocation clause absolutely has to be in there, but it's something to keep in mind when you want like-kind space. If you're going in a specific spot because you need traffic, foot traffic, and you're going in the corner and you're not near the Publix because you need to be for the type of business you have, then those are things you need to think about for those relocation clauses. It's very important that people don't think about. I'm in the shopping center. What does it matter? Well, I always say there's multiple buildings sometimes in a shopping center. So if you're going to relocate me, I want to be in the same building. That's another option as well than just allowing to say relocated in the shopping center, 6 buildings.
Is it better if the landlord just strikes?
I have a lot of landlords that won't strike it. So I just compromise with the termination.
Well, if somebody wants to expand, right? So you got the Publix and they want to expand or they want to accommodate their anchor tenant, so.
The same goes with, and we didn't talk about this in the provisions, but it occurs to me, subleasing and assigning. And I've seen it on both sides. I've seen it where a tenant has complained to me, well, I needed to get out of this space. I was closing, it was a restaurant. I was closing down the restaurant. I had another restaurant tour that wanted to come in and take it over, and the landlord never responded, and I lost the sale of my business. I want to sue for the sale of my business. That's very difficult. I mean, that's all prospective. That sale may not have happened for a myriad of other reasons. But there was nothing in the lease that said, landlord must agree, cannot withhold the approval unreasonably. Even that will give us a way to get some leverage and say, look, you're being unreasonable. We've given you the financials. We've given you all this other information that makes it a reasonable assignment, and you won't do it. That's actionable. But if it just says you can't sublease without landlord approval, the landlord could just say, I don't want to approve it. And the same may go the other way around. The landlord may say, listen, it's in my sole discretion, period. I'm not gonna get into a debate with the tenant about who they're gonna assign it to. And that's a valid argument as well, but know what you're getting into, because once it's in there, you're not gonna have leverage to get out.
Would it be accurate to say that sole discretion could otherwise be read unreasonably withhold?
That's correct. I mean, that's what the landlord is saying. I don't care how reasonable it is, I'm not gonna agree to it. And that's a right that someone can exercise if they negotiated it and it was agreed to. And the same thing with subleasing. I've seen it where people just sublease. And then the landlord comes in and goes, I didn't approve this. This is not approved, you can't do this under your lease. The question is, when it's silent, do you default to you can't do it unless it says you can, or you can't do it unless it says you can't? So, that's when I get involved, see? So.
So you know how you typically see a repair provision that says in the event of a casualty, the landlord will exercise due diligence to repair whatever it is, and during the time period within which if you cannot use all of your space, then the rent will equitably abate. So you have 100% of your premises, you can use 75%. Everybody thinks it's fair because you're only paying 75% of your rent. There should be an outside date by which if it turns out that the 25% doesn't ever get repaired because of practical reasons and they rebuild it that way as a tenant, you're like, wait a minute. I mean, it's great that my rent is 25% less, but now my business has 25% less space. I mean, it's just something that's not typically addressed in that provision, but you need to think that abatement of rent is great, but it might not protect you ultimately under certain circumstances. Oh, that's just something we saw in COVID where there were leases that say if you abandoned the premises, then you're in default of the lease. And then if you represent the tenant, you might want to say, as long as I'm paying rent, then you can default of the lease.
So the pandemic language in the public health orders language, I put in a few spots in the lease. I kind of sprinkled it in. This abandonment is one of the sections I also put in.
Now, Florida statute does have a specific definition of what is abandonment. So we'll have landlords that will call and say, the tenant hasn't been there, they closed up, they've abandoned. Well, okay, let's go through the steps. And so the statute will lay out, I didn't bring that statute with me, but the statute will lay out if they've been gone for, I forget how many days, and have not returned, if they've expressed that they're not returning, etc. You may not want to, as a landlord, to say they've abandoned and I'm taking over, because once you take over and you take possession, you may have triggered you've terminated, and now you can't collect the rest of the rent. So you have to be very careful how you do that. You want to give a certain notice. You want to say, it appears you've abandoned based on these criteria. I am retaking possession for your benefit so that I can try to release it and give you credit, but understand the lease is still in full force and effect, and you're still liable under the lease. I am not terminating the lease. Sometimes people will give the wrong language. I've seen landlords say, you are not paying your rent and you've abandoned, I'm terminating the lease. Okay, well, if you terminated the lease, they no longer have any more obligation under the lease, including payment of the accelerated rent. So you have to be careful with the words that you use. Taking possession is different than terminating. You don't want to terminate. You want to repossess and relet under certain circumstances, abandon being one of them. Okay. Price is over.
Oh, this is just something if you're representing a medical professional, we have the typical provisions in there that the landlord has the right to access the premises, and in the event of emergency, they don't have to give notice and that sort of thing. You might want to carve out the obvious, which is that they're not allowed to look at anything that would be a HIPAA violation, whether you have a safe or a vault or medical records or patient rooms or that kind of thing. You might want to carve that out to avoid some HIPAA compliance issues.
Can I just ask a question back a step? Back to COVID, and that we want to leave that way behind. Force majeure, and does that apply to COVID or not? And what is force majeure? How does it work?
Force majeure is like act of God, and it's things like hurricane control. Yeah, out of our control. Not in anybody's hands to fix, or if the roof gets blown off during a hurricane and the building's unusable, tenant can't say, well, you constructively evicted me and therefore that's a violation, you're in breach of my lease. That provision would protect the landlord by saying, no, you're temporarily out of the space due to something beyond our control, force majeure. That argument is being made all over the United States right now. Is COVID a force majeure? Is that sufficient to say, we had tenants that were saying, oh, landlord, you're in breach because you're prohibiting me from possession of the premises. And the landlord is saying, I have a government mandate saying I got to close the shopping center and I can't let you operate. There's a lot of questions that have not been sort of fleshed out yet. We're getting some decisions, some out of New York, I believe, where they're saying it is a force majeure, and there's certain exceptions where the tenant doesn't have to pay or there's an abatement. Then we've got other courts saying it's not a force majeure and you are, you're still liable and all the obligations of the lease are still in full force and effect. So it's going to be interesting what comes out of there. I don't know currently. Do you know of any Florida? I don't know of Florida.
I think on the insurance side, you know, a lot of tenants reached out for business rent, loss.
Yep.
Provisions, and the court cited that it was not an act of God that therefore triggered their payouts. So,
On that, on insurance, that's an interesting topic as well, because on insurance, there's actually a form that you have to have for business interruption, for pandemics, and I think it actually has to be for virus or bacterial pandemics. It's very specific, but it's actually a rider to your business interruption. And they do have something, but no one ever gets it because who would ever think that you'd ever need that?
They will now.
That was one of the things that, reasons why they excluded.
like terrorism coverage.
Oh, you touched on this earlier. We just had a situation where we had a tenant and they know over the life of the lease, it's a family owned entity and they're going to be, passing the torch to their children or something along those lines. And you can run afoul of some of the assignment provisions or sublease provisions or transfer provisions in your lease, where it says if you turn over majority control or beneficial ownership interest to someone else, that triggers an assignment and you have to pay a fee to the landlord and they have to review and prove it. So just talk to your tenants if it looks like during the life of the loan or foreseeable lease or foreseeable renewal, that they're going to be doing some sort of succession planning within their entity to get ahead of that. That's all, just get one.
Personal guarantees being a big one, where the business has changed hands. It went to mom and dad, and it went from mom and dad to son, daughter-in-law, but mom and dad are still on the hook for the personal guarantee. And the landlord is saying, I'm not going to change it. Mom and dad are the ones that it's their credit worthiness. I'm not changing it. Well, that can be complicated, especially if mom and dad are retiring. It's difficult, for a number of reasons. So again, in that planning ahead, think about that. And if that means that you're going to have to give the landlord your credit, the credit worthiness of the successor at the start, plan for that. Get that done, get ahead of it so that it'll be a smooth transition.
This was the point that we had this come up where if the disruption in the utilities is within the landlord's control to remedy, then after so many business days, maybe you'll get an abatement or credit of rent. And this had to do, I'm being a little vague, but a situation in which sometimes it'll like the tenant is responsible for paying utilities, but the landlord controls the building and there's a problem, put some incentive for the landlord to cure it by saying the rent's going to abate if in fact it's the landlord's ultimate responsibility or the one who has the contact to make the utilities come back. Okay, so this is having to do with, I don't know if that fits things. The landlord has a lien, but then everybody knows that a tenant is going to go ahead and they're going to be have vendors and suppliers and business lenders that are going to be financing their goods. And so maybe you want to ask the landlord to subordinate their lien rights to the tenant's rights, to the tenant's vendors or lenders. And the tenant also maybe wants to carve out, this is on the HIPAA thing, business records, patient records, and all those things that practically speaking, it sounds difficult. Can you talk about, like, practically speaking, what really actually happens with the personal property?
In Florida statutes do provide that a landlord has a lien, so we call an inchoate lien. So it's going to develop, or it's sort of silent until certain things happen. For any unpaid rent, and that lien attaches to the personal property or the tangible property of the business that comes on site, or even not of the business, any property that's on site that becomes part of that rental space. It does become a little complicated in that, as a landlord, you can't just come in and go, okay, I'm taking all chairs, all tables, all copy machines, I'm taking everything. Okay. There is a way to do it. It is through a legal process. The lien, that's why I say the lien is inchoate. You don't have to do anything to perfect the lien, but if you want to effectuated and you actually want to seize property because of that lien, then there is a process, it's called replenishment, and you go through the court system so that you can take that property to satisfy the lien for rent. To the point that was just made, depending on the kind of business it is, a lot of the things in there really don't belong to the tenant free and clear. There's, again, equipment that may be leased. There may be companies that have liens already on that property that have been registered with the state for secured, they're secured by the equipment, or it's secured by all of the personal property of that business. The bank may have a lien on that as part of a loan that was made to the business. So it's not that simple, practically speaking. If sometimes landlords can think, well, I'm not worried about it because, they sell high-end merchandise or they sell high-end equipment and I'll get my money back that way. You have to think about who might have priority as to those items. Having said that, it is a tool that landlords sometimes don't use. They've got a warehouse full of stuff that may have no other liens on it, and it may allow for some recovery of pass-through rent. So it is something to look into, certainly. And sometimes you can do that even before the lawsuit is over. You get what's called the break order or a pre-suit replenishment, which allows you to go and take those items even before you're done with the lawsuit for possession or the lawsuit for damages for the full amount of the rent.
And in leases, when tenants are doing improvements, there should be a provision in there that says that they are going to notify that their subs cannot put a lien on the property, that the landlord has priority. So there is a specific provision that should go in all tenant leases that when tenants are doing improvements.
Right. So mechanics liens and things like that.
Along those lines, isn't there something you actually have to file so that like a mechanic can't place a mechanic's lien on the building without
You have to
signing off?
record it. Right, correct.
It's something that doesn't happen in a lot of buildings that it really helps landlords do. If you're representing a landlord and you don't know about that, maybe ask one of these ladies about that after this.
So we only have a few minutes left, so I'm gonna go through this. You want me to talk about the energy? And then we'll come back. Yes, sorry. So real quick, because again, we've been talking a lot about having the provisions and enforcing the provisions, but how do you actually do that? So when tenants don't pay their rent, that's easy, right? You give them the demand, it tells them how many days they have to pay, otherwise you're gonna start eviction process, and the eviction process has a very specific way that it flows through. But what happens when they're in default of non-monetary provisions, such as what we've been talking about? Can you really enforce that? Well, the first answer is yes. Any obligation of the lease is enforceable. And if you needed to evict someone and take and repossess the property because they're not following certain obligations under the lease, even though they're paying their rent, you can do that. There are provisions and a way to do that. But however, I think a lot of landlords are hesitant to do that. So the lease says the tenant is supposed to give me copies of all their insurance policies, and they haven't done that. So I really want to kick them out, a good paying tenant, and try to find another tenant because they're not giving me copies of this. So the answer is there's an in between, okay? In between doing nothing and allowing these non-monetary defaults to continue or kicking them out, there's probably some things that you can do to try to get them to comply. First of all, don't ignore it. Do send a breach letter saying you're in breach of these obligations. And again, that's something that you strategize with your attorney. How much time do you want to give them? What kind of a deadline do you want to give them? And then what are you going to do when they don't comply, or if they don't comply? We're talking to Joe, he brought up a great point, which is some landlords have incorporated into the leases monetary penalties for not complying. I think you have to be careful in how it's all wordsmithing. You have to be very careful in how you lay that again out in the lease. We don't want to make it a penalty necessarily, but like an administrative fee. If I have to continue to follow up with you every 2 weeks because you're not giving me copies of things you're supposed to give me, we're going to charge you for that. There's going to be a $50 tack onto your rent. There's going to be a $100 tack onto your rent, or it's going to get increasingly more expensive for you not to comply. And then it's very critical that somewhere in the lease it says any of these additional administrative fees are part of the rent. So that then if you have to go forward and try to evict based on these non-compliances, or because they're not paying their rent, all of that is already built in there and you are going to demand the full amount, including these administrative fees that have been part of the enforcement of the non-monetary default. So yes, they are enforceable, and yes, as attorneys, we would advise you to always stay on top of those obligations.
And your lease should.
Right. And it should say
that
that
you can force place as well and add it on to rent.
great
Force
point.
place or insurance.
And warn them and say, listen, you haven't given me a copy of your liability insurance, therefore I have to assume you don't have one. So we're gonna force place it, and that's gonna be a liability that you have to pay for. And any other maintenance issues as well, extermination,
maintenance contracts is a big one.
It's like a
maintenance.
lender maintenance.
Yep, especially for the air conditioner, as we were talking about. You want to, if it's on the tenant, make sure they're doing it. You don't want to find out at the end of the lease that because there's been no maintenance on these air conditioners, they're now in a terrible, deplorable shape, and now it's too late for you to do anything about it. And then follow the provisions, as I said, and then make sure you document it all. Don't just have phone, we're very used to text messages, which is fine. You can send a text message, but follow it up with either a formal letter that you send pursuant to whatever the lease says is the correct way to give notice. If it says email, do it by email. If it doesn't say email, again, going back to, I've had this lease for 20 years and it says you have to mail things. So if you sent it via email, you didn't really give valid notice because your lease says you have to mail it, or certified mail, or whatever it might say. Always follow it up. One of the biggest nightmares for litigators is people go, I have it all documented. I have it all documented. Okay, send me the documentation. And I get this long trail of like 2-word text messages going back and forth for 6 months. It's maddening. Think about how that's going to look in court one day when I'm using that to show the court that you provided notice or that you agreed to an extension. That is not the best way to do that. It becomes very, very difficult for the court to follow. Okay. Lastly, there is a specific statute that addresses this. So it should be in your lease, but even if it's not, or you have an old lease, or you didn't think about it at the time, there is a Florida statute that talks about reasons why you can remove a tenant. And within that is the fact that they are continuing to stay in the premises after they have failed to cure a material breach of the lease other than non-payment. So if your lease provides a specific procedure for that, you follow your lease. If it's silent on that, then you follow the statute which says that you have to give the tenant at least 15 days, a 15-day notice, an opportunity to cure a default before that you can proceed to evict or sue them for the breach. One thing to keep in mind, it does say material. So while we do think it is important to enforce all provisions of the lease, if it's not material, you just don't like the tenant, they're just doing things that are annoying to you and you're trying to get them out, that may not be sufficient. You laugh, but I've had people call me and say, I don't like this tenant, how can I get them out? It does have to be material. So you can't, the court's not going to agree to allow you to evict somebody simply for small little violations that can be easily corrected. They're going to expect you to act in a reasonable fashion. And it does have to be material in some way before it'll be sufficient for an eviction. That's my spiel.
We're out, okay.
All right, we're pushing right up against the edge, and I forgot to do something in the beginning, so I want to reserve 2 minutes at the end for new members, and this is our first time meeting in person. But first and foremost, let's put our hands together for these. I think we probably just scratched the top of layer of things to worry about in a lease, and I think one of the things in the way we set this up, we noticed we didn't have a handout with clauses and different things because the work that they do requires years and years of training and expertise. And that's where I think we get our landlords and ourselves in trouble so much as we take things off the shelf and say, this has worked in the past, it'll work again. And I think what you highlighted for us is that may not be the case, and we really need to have a professional give us that advice. And I want to remind everybody from a realtor standpoint, it's illegal for us to write leases. So just be careful on that with applying the knowledge that you received here today. I want to thank everybody who came and showed up in person and was able to be here. For anybody who's followed us online, thank you. We look forward to seeing you next month. I'm not sure this will be an option for you to digitally sign in next month. We're still working through that. I do want to give an opportunity for any new members to announce themselves, and or I think Susan wanted to introduce some new folks at Michael Saunders.
So I'm gonna lay down the challenge. We get to have 3 brand new members of our team that I want to introduce you to. So before Michael Saunders get the award, Joe, you might get the award for attendees from a firm. I'll give you that, but I'll start with, we've got Melinda Garrett. Aaron, oh gosh, does Aaron do it? Pretty right, okay. And then Amber Gesson.
Do you have any other first-time attenders here today? I see a couple. Even if you're not a realtor, if you're an affiliate member and you'd like to introduce yourself to us.
Yeah, we have Nick Kinsella, who's our summer intern in the back. Yeah, that's right.
We have 3 summer interns here with SBN. Peter Kraus, Joel Sedon, Mike Van Ness.
Welcome. We look forward to joining our commercial real estate community. Guys, thanks so much. Want to be respectful of your time. It's just hit 1300. Thanks for coming today. Yeah, there are some giveaways on the different desks. Those are for your enjoyment.